The only other thing I will add is, and in essence, my memo is my closing argument if you were inclined to take argument. The only thing that isn't in there that I would add is that Mr. Taylor's second prayer for relief, letter B, not only asks the court to invalidate the process, but essentially asks the court to order a restart of essentially the same process. And while we're certainly asking the court to not invalidate the process, I think the evidence today shows that this board was trying to get it right. Although I know Mr. Taylor will never accept that. They were trying to get it right. And I do think, as I said earlier, it would be an unwise use of your discretion to invalidate the process.
Are you conceding there was a violation of the right to know law?
Not with regard to the ballot issue, no.
Why not? Wasn't that a secret vote?
Your Honor, I don't think that culling process whatsoever constitutes a ballot. I think it constitutes board members giving input. I think then the names were drawn, and then a vote occurred in public meeting.
Well, wasn't there a vote on who should make the final cut?
I don't accept the characterization that it's a vote. No, I don't.
All right.
So in any event,
if it was a vote, it violated the right to know law, didn't it?
If it was a vote?
Yes.
It didn't occur in the meeting. The only thing the right to know law says that in a public meeting you're not supposed to have secret votes. It didn't occur in the meeting.
So they can have secret votes as long as they're not meeting?
It's not what I'm saying.
Well, that's what it sounds like.
But again, I would reject the claim that it is a vote. I think it was a process.
But if it was a vote, it violated the right to know law.
I wouldn't concede that now.
Why not? Because they didn't have a meeting at which the vote was taken?
I think I go back, Your Honor, to the fact that they could have picked the members of the subcommittee in any number of ways. And if there's anything flawed in the process, it's been cured. The names have been released. The names have been provided. And I just don't think, I certainly don't think if it is a violation, it's a violation that warrants setting the process aside.
I'm trying to get past the first question now. You do not concede there was a violation of the right to know law?
I don't think I can, Your Honor. I don't think I can. And the only point I was making is that, and I understand, I certainly can read the tea leaves. I understand what you're saying. If the court is inclined to find that despite the board's efforts and reliance on Mr. Levesque, that it should have acted the way it acted, I would ask you to not go so far as to invalidate the process. And were you to do that, I think that the relief that Mr. Taylor has asked for is more than he's entitled to. Because he's essentially asked you to tell the board to use the very same process next time. I don't think that the court has the power to do that. I think the board would then need to meet with its consultant group and start anew, something I hope you don't order them to do.
I don't know what I'm going to decide on that, whether there was a violation or not. But if I did decide there was, is there any remedy that Mr. Taylor is entitled to?
Well, the statute certainly lays out remedies. But I don't think that this would call for invalidation of the process.
All right. I didn't mean to cut you off. Anything else?
No, that's it.
All right.